All right, good morning, everyone. So again, my name is Erin Fueury from Alpine Legal Services here, and today I'm going to be trying to cover incapacity, estate, and family law matters for real estate transactions. Of course, it also correlates into estate planning in general. So feel free to ask any questions you might have about that at the end, even if it doesn't necessarily deal with real estate. So we'll begin here. So incapacity, just to kind of give an overview, it's as it comes down to it, it's really a case of legal question, not a medical one. Some people get those two confused. Different thresholds can apply at times. Of course, when you're receiving professional medical information as to the capacity of an individual, that's something that you can lean in and take as a consideration. But it's not black and white, especially with dementia. I think a lot of times you don't see cases where someone just all of a sudden wakes up and now they're in a state where it's dementia. Sometimes it can be a progressive state. Sometimes, they have good days or good parts of the day. And then another issue too is the physical incapacity. So again, illnesses that are coming up, a client might not be able to meet or sign with anyone or sign documents at all. And if you have no capacity, you can't sign legal documents. So what does it mean? If a client loses capacity, they can't sign their closing documents for a purchase or sale. There's always the risk of default under that transaction and consequences that follow because they're still liable for that contract. And it is a high bar to argue the contract should be frustrated due to incapacity. That's something really important for people to be mindful of, is that threshold you have to make for making that argument is high. It's not a low one. And purchase transactions can still be salvaged if remaining purchasers are able to complete in their own names. So sales transactions do present a challenge, especially if you're dealing with now trying to get a power of attorney to step in. So again, that kind of bleeds into this part is what can you do? If you believe it may be a potential issue, you want to advise the client to have a power of attorney made just in case in advance to avoid any issues with closing. So power of attorneys can kick in. There's different types. You definitely want to speak to a lawyer about what type exists. If there's one that's in the woodworks or there's one that might kick in, letting us know. And especially if one or more of the clients appear to be ill, comment, if they're going to be going in for major surgery, elderly clients where closing is further out may also be at risk. These are all things that we just keep in the back of our minds. But yes, power of attorney must be prepared by a lawyer or notary. Self-made or bank power attorneys are not usable for land title purposes. Also for power of attorneys, those are things that we need to have filed with land title. But yes, power of attorney, we say it's a cheap insurance and it's good to have in place regardless. It is valid until they pass away. That's when the will would kick in to govern the estate from thereforth. And we regularly see clients at care homes, hospitals, hospice. We do offer mobile services. This is largely just for preparing estate planning documents. And you never know, situations can turn. They might need a lawyer to step in to get documents done. Better late than never. And what do you do if a client is now incapable, and if there's no power of attorney in place and it's too late to get one and the transaction cannot complete, then you have to apply to court to get a grant of comity. And this can take a few months at least and require court application to be made, court orders, and it's a very technical and confusing process. A lot of lawyers actually do not advertise or will not go and do a grant of comity. So sometimes it's even tricky finding a lawyer that's within that scope of their practice to do that. Contract can be amended to complete when the grant is obtained. That's another option. Without an extension or mutual agreement, the contract may be found to, or the client may be found to be in breach of it. So estate matters. If a client is to pass away, they can always add their spouse to title as a joint tenant, and then if they pass away, the title would then flow to that other spouse. This could also add a beneficiary. It can also add a beneficiary as a joint title, so that title property transfers to them. Always, they should get a will done. It's always, I say case by case, so I can't say like, oh, this is what everyone should do. It's really depending on case by case, of course. Much easier though to get a grant of probate with a valid will than no will. So again, cannot stress that enough. People should have wills, get wills done. If there's like a major life change coming up, it's good to have that will revisited as well. And if you're in a crunch, then self-made wills can work if there's no time, but they can also be plagued with issues, especially if some family members after the person has passed away disputes them. It's really tough It's a lot easier, I guess, to dispute a will if that will was made last minute, because there's more angles that person can try to attack that will. But we do regularly do last second wills, and we have the option to do them remotely. So that one though is with the huge, like, I think it depends on a case by case. We try not to do remote wills because, again, the risk of it being successfully disputed increases. We do largely hospital visits because we have to also determine if the person has capacity to sign that will, right? If client passes away, was the property held in joint tenancy? So like I earlier mentioned, does it flow to someone else? If not, or if so, has the transfer to the surviving joint person been filed with a lawyer? There's no joint tenant, or if the property was held as joint tenants in common, then a grant of administration, if there's no will, or grant of probate must be obtained. So just to clarify that, tenants in common is different than joint tenants, because tenants in common, if someone passes away, then it doesn't flow, I guess it would flow to their estate. If they have, if they passed away and there's a will, it would flow to the estate versus all of the title flowing to that other person. If listing on behalf of an estate, so ensure completion date is tied to the date on which the grant of probate or administration is obtained, or have a the important thing is to have a subject condition for the benefit of the seller, that the grant must be obtained, because it's hard to tell when you're going to get a grant of probate, even because it largely goes through the court and you have to rely on the court. I can say, like, especially around December, staff are going on vacation, so you don't really get, there might be, like, for some reason, sometimes you'll also hear from the clerks that they got a huge amount of wills coming in last second to probate, or probate applications last second. So that can back up the process, and we have no control over that, right? So that makes it hard when there's going to be a completion date. And if the executor is appointed in will, they can sign on behalf of the estate as long as the subject conditions are still in place, as they won't have official authority to act on behalf of the estate until the grant is actually obtained. In a volatile market, there's a high risk of a dispute arising between the estate and beneficiaries if they believe the listing price was insufficient. So we're seeing that too, is a lot of people will list their place for a higher amount than maybe necessarily they're being advised by their realtor is appropriate. In these cases, maybe better to support the amount with an independent appraisal, but it creates a lot of issues too for the beneficiaries if they're operating from a mindset where maybe they're one of their view of what's reasonable is different than another's. There's a lot of stuff that can also correlate with family matters. I'll kind of breeze through this because a lot of this deals with like a separation or divorce for sales. But you always want to be wary of acting for both parties, even if they seem amicable. I always say that because everyone wants to have an amicable separation, but it's one of those situations where lawyers cannot just act for both parties. It's very high risk. There's likely to be a conflict that will come up when you're trying to navigate those waters. I think that's covered there, but yes, always good to have an independent valuation to support price for selling or listing a home, like a home appraisal. That's always helpful. And if clients are going through a separation or divorce, highly recommended that they get a separation agreement. I know a common question we have come up is, can you just sign off on a separation agreement? No. Lots of liability. So I will not be able to sign off on a separation agreement. But most lenders do require one. So it's important to get ahead, meet with a lawyer, get that done properly. But yes, I know that I'm running out of time, so I'll skip through this to the end. If there's any questions, please feel free to ask. Thank you.
That was a lot of information.
Yes.